All right. So, here we go. Do any of you have a wife? Because they're annoying sometimes. Anyway, so, welcome. Welcome to this live stream, to my friends and patrons. We're going to start doing probably some more live recordings that you can participate in. They'll be generally around this time of night unless otherwise announced. But, it'll be a first-hand look at the videos. And if you want to drop in chat, since there's going to be a lot less people in these live streams, you'll be able to ask questions or whatever, and I will try and answer as I see them. I can see the chat, but I'm not going to focus on it. If you tag me, it will help me get to any questions. If you tag me, I'll see it because it actually gives me a visual cue. So anyway, tonight we've got two documents that have come out. The first one is a letter from Weber Shandwick, and it is in support of a motion to move this proceeding to the Commercial Division of New York. And we're going to go through that real quick. And I did not catch this from Dick's lawyers before because, again, as stated, I'm a Minnesota practitioner, not a New York, and they have a different process. So Dick filed, or Dick's attorneys, I guess. While we're at it, I'm drinking the wheat whiskey again. So from 45th Parallel, again, not a sponsor. But maybe they should consider it since I'm drinking their whiskey online. Seems rude to not sponsor me. But anyway, so Dick's lawyers have filed a motion. It's actually a request for judicial intervention. And if you go onto the document list, I'm not pulling it up here because the request is very basic. I think I may have mentioned it before, but It's just a form letter or a form document that New York courts have that the lawyers for Dick have filed. And what I did not know was it was a request to remove this into the Commercial Division, which has a different set of rules that we'll talk about briefly. I'm not going to spend a ton of time on it. And I'll talk about why I think they did this. And it seems to be a good move. So here's the letter from Weber Shandwick. Dear Justice Kaplan, this firm represents Weber Shandwick and Kaufman. In the above captioned action pending in the Supreme Court for the New York County, I write pursuant to Section 202.7e of the Uniform Rules, trial courts, to apply for transfer of this action into the Commercial Division. On November 11th, Uzunian and Doe, Jessica Blum, filed a complaint against 10 defendants alleging 16 causes of action seeking $20 million in damages. And I've seen this question before. People are asking if it's actually $20 million in damages or if it's actually $400 million or $380 million in damages, as Dick has stated on his show. I think the appropriate response is that it's probably $20 million, but due to the incompetence in drafting of the complaint, it's actually for like $400 million. But I think the intent was for an overall $20 million. But like so many things in this case, they failed to even ask for what they meant to ask for. So, because I've said this before, but typically you don't put your damage request or your relief request in with each cause of action. You would typically lay out each cause of action, and then at the end, you have a final request for relief in which you ask the court for what you want in sum, not in part. And the court's going to decide. Like, it doesn't matter if in each section you ask for $5 million or $1 million or $20 million, as Maddox did in his complaint. Ultimately, you ask for what you're going to request in total, and the court will determine what the appropriate number is. Maybe it's less, maybe it's more. Really, the only damages you need to mention are as if you're asserting that they're above or below a certain threshold. For example, if you're filing in district court, in federal district court, you need to exceed $75,000 in damages, as a reasonable assumption. So you would say that you're asking for damages in excess of $75,000, and that's all it takes. Alleging $20 million is, it's weird. Even if it is $20 million, which everyone knows it isn't, but even if it were $20 million, you would just allege the amount in excess of whatever you think it's in excess of. But since Maddox picks such an astronomical number, it actually allows this to be moved into the commercial division, because the commercial division in New York City courts, has a minimum threshold of $500,000, which is higher than any other district in New York. And Maddox may have been able to keep it out of that commercial division if he hadn't requested such a massive damage amount. Had he requested, say, $250,000 in damages, which, let's be honest, might come close to being reasonable if we assumed everything to be correct. If he had asked for that, the commercial division wouldn't have been able to take it. And there are some advantages for all of the defendants going into the commercial division, and there are very little in the ways of advantages for Maddox due to the nature of the complaint. And we'll get to that. I'll talk about it in a second, but let's get through this here. The claims asserted in the complaint, include the following: misappropriation, unfair and deceptive trade practices and unfair competition, tortious interference with contract and a business relationship, invasion of privacy, defamation, intentional neglect and negligent infliction of emotional distress, various negligence claims, conversion, deceptive acts, and misleading business practices / false advertising in violation of the CPA, fraud, and violations of New York General Business Act 349-350 and the Federal Trade Commission Act. Defendants Dick Masterson, Foundation Digital, and Bozer filed a request for JDI on January 2nd. The January 2nd RJI designates the case as commercial in nature. It does request assignment to the commercial division. I've reviewed the standards for assignment of cases to the commercial division set forth in 202.70 of the Uniform Rules. And this case meets those standards. I therefore respectfully request this case be transferred to the commercial division. Monetary threshold for New York County commercial division, $500,000, is met because the plaintiffs seek $20 million in damages, exclusive of punitive damages, interest, costs, disbursements, and counsel fees for this action. Furthermore, the commercial disputes in this case fall within the standards set out in Section 20270B1 because the complaint alleges various business torts, fraud, misrepresentation, and various violations arising out of business dealings. Complaint does not include any causes of actions of the types listed in 202.70C as not belonging in the commercial division. So then Munoz has asked the court to move in this way, remove it to the commercial division. And that is absolutely reasonable. That's probably what should happen here. So a quick look at the rules. So here's 202.70A. There's the monetary thresholds and then the commercial cases. I'm not going to read through this because this is just boring. And Munoz Munoz, that guy, he summed it up. All of the claims fit within the commercial division's jurisdiction, and none of the claims don't. So then, within 90 days following the service of the complaint, any party may seek to assign the case to the commercial division through an RJI. That's been done because it's 90 days following service, not 90 days following filing, although I think we're still within that filing time as well. And then, the parties to a contract, this doesn't matter. So then it gets transferred to the commercial division. Let's see. So Maddox's attorney had a chance to resist this. If an RGI is filed within the 90-day period following service of the complaint and the case is assigned to a non-commercial part because the filing party did not designate the case as commercial on the RGI, any other party may apply by letter application to the administrative judge. Within 10 days after receipt of the copy of RJI for a transfer of the case into the commercial division. Oh, well, okay, never mind. This section doesn't matter because they did request it to move into the commercial division. Further, notwithstanding the time period set forth in D and E of this section, for good cause shown for the delay, a party may seek the transfer of a case to the commercial division by letter application to the administrative judge. Wait, this doesn't matter. Here we go. Any party aggrieved by the transfer of a case to a non-commercial part. Oh, never mind. I'm reading the wrong stuff. Bear with me. Again, I researched this like 10 minutes ago. Here's the most important part. And I make weird sounds when I read because I'm trying to annoy you. Here's the important part. This is where things get interesting. The preamble to the commercial division. Right here. Oops. Seriously. Okay. The commercial division understands that the businesses, individuals, and attorneys who use this court have expressed their frustration with adversaries who engage in dilatory tactics, fail to appear for hearings or depositions, unduly delay in producing relevant documents, or otherwise cause the other parties in a case to incur unnecessary costs. I mean, what does that look like? Or sound like, I suppose? That sounds like Maddox, right? It sounds like Maddox trying to drive up costs. This entire thing, this entire action is meant simply to cause damage to everyone involved. It's meant to cause financial damage to Dick, financial damage to Asterios. It's meant to cause reputation damage to Weber Shandwick and pressure them into firing Asterios. It's meant to cause reputation damage to Patreon, although that was probably a mistake, and we'll talk about that when we get to Patreon's motion in just a minute. But it's just meant to cause damage. He can't honestly think he's going to win. Not with the complaint he drafted, not with any of the evidence, once it comes to light, is going to show just what a ridiculous pile of garbage Maddox has been during this process. So anyway, commercial division will not tolerate such practices. Commercial division is mindful of the need to conserve client resources, encourage proportionality in discovery, promote efficient resolution of matters, and increase respect for the integrity of the judicial process. Like this commercial division, I was reading up on the history of it. It was completely made for the sole purpose of getting out of the overburdened regular court system that was getting complaints that commercial cases were being dragged out for months and months at a time when they could be resolved much quicker. So they created this place for businesses who might engage in litigation at a more frequent rate than your average person, and it allows them to be professional, very professional, in a very efficient. As far as courts are concerned anyway, no court is actually efficient, but in the most efficient way possible and permittable under law, and it allows them to really go after people who violate that stuff. So, litigants and counsel who appear in this court are directed to review the rules regarding sanctions, including the provisions in Rule 12 regarding failure to appear at a conference, which might be funny if your lawyer's like in Michigan, if he decides to not appear at a conference, or if you are in California and maybe don't have as much money as the other party that you're suing, maybe it might be harder for Maddox to appear in New York. Who knows? Hopefully he's been saving his Christmas money that he doesn't spend on other people to buy plane tickets. Rule 13A regarding adherence to discovery schedules, and Rule 24D regarding the need for counsel to be fully familiar with the case when making appearances. This is funny to me. This is funny to me because I don't think Landau has any idea what's going on in this case. I don't think Landau has any idea what's going on. And suddenly, Maddox may have to pay him to familiarize himself with every document if they have to make any appearances. Because he's going to have to appear ready to describe every motion. He's going to have to appear ready to describe all of the factual allegations from all of the parties in this case. And, we'll see if he's up to that. Sanctions are also available in this court under Rule 3126 of the Civil Practice Law and rules and Part 130 of the Rules of the Chief Administrator of the Courts. These are for failure to comply to court orders or failure to comply with court rules and discovery requests and stuff like that. So if Maddox was just... If Maddox were to, say, not keep up with his end of the requests coming from the 10 different defendants, right? All of these defendants will be able to make requests of Maddox. And that gets really funny. Like, if we go to trial, the amount of money that Maddox is going to have to spend is comical, because each one of them, each of the 10 defendants could request a deposition of Maddox. And each of those depositions could be 7 hours long. And Maddox would have to bring Landau to all of them, which means he'd have to fly him from either Michigan or New York to California, probably, because you have to take depositions where convenient for the party being deposed. So this would actually be a burden on Dick's counsel, unless they wanted to hire a firm in California to do the deposition. And maybe Maddox would want to hire a firm in California to represent him in the deposition. Not sure. Either way, Maddox could have 70 hours of depositions, but each other party could only have 7 hours against them. So this is a pretty funny move if this were to go past summary judgment. I don't think that's going to happen. I don't think it's going to go past summary judgment, but if it does, being in the commercial division will have its benefits. The judges in the commercial division will impose appropriate sanctions and other remedies and orders as is warranted by the circumstances. And this, like, having sanctions and remedies as warranted by the circumstances, bringing a frivolous action to a commercial court, is going to be reviewed with more scrutiny than it would under the general court. Use of these enforcement mechanisms enables the commercial division to function efficiently and effectively and with less wasted time and expense for the court, parties, and counsel. Nothing herein is intended to expand or alter the scope and or remedies available under the above-cited sanction rules. Here's the thing. The above-cited sanction rules are actually pretty broad because the courts have broad authority to impose sanctions or award fees when they think an action is frivolous in New York. And that is where Maddox is going to have real trouble. So the next part, I'm not going to go through all of these rules. Don't worry, there's a whole bunch. Appearance by counsel with knowledge and authority. I mentioned this earlier, but counsel who appear in the commercial division must be fully familiar with the case in regard to which they appear and fully authorized to enter into agreements, both substantive and procedural, on behalf of their clients. Counsel should also be prepared to discuss any motions that have been submitted and are outstanding. Failure to comply with this rule may be regarded as a default and dealt with appropriately. This means that if Landau shows up and he is not familiar with a motion, it is a default and they lose on the merits. They're done. This amounts to increased costs for Maddox, ultimately. The other parts of these rules, I've skimmed them. I am not an expert. But the ultimate part of these rules is that it streamlines all of the processes. It condenses the timelines. And here's the most important part. It gets this matter in front of a judge who every day is hearing only commercial cases. So when they see that all of this is based on Rule 50 or Rules 50 and 51, which have to do with, misappropriation of name or likeness, they can immediately dismiss it. And they can dismiss all of the other actions when they see, because they do this all the time. Whereas a regular, a traditional tort judge isn't going to be necessarily, like, they will consider this in a commercial sense. I don't want to denigrate their expertise or their ability to rule appropriately. But these guys do it every day, and they see actions frivolously brought against businesses, especially like Weber Shandwick and Patreon, every day. And they're the people who dismiss this stuff constantly for failure to state a claim, and they're going to know what those claims require at a much higher rate than someone who may have to cover criminal law, who may have to cover family law as well, Courts of general jurisdiction, those judges have to be generalists. They have to know everything and all of the rules for all of this different procedure, or more appropriately, they don't have to know them. They have to be reminded by the lawyers, and they rely on the lawyers to direct them to the rules, because one, that's the lawyer's ethical duty, and two, it saves them having to know all of this stuff. Now, they will acquire that knowledge over time, but expecting anyone to know all of the rules in any jurisdiction is nonsense. And anytime you can specialize a court, it's probably good for the person who has the case and probably bad for the person who doesn't. So that's this document. That's what they're doing here. They want this to move into the commercial division. Dick's lawyers do too. Sorry I missed it due to my lack of experience in New York, in the New York forum. But they want to move it because moving it to a court of expertise only helps the defendants. It doesn't help the plaintiff in this case, because the plaintiffs don't seem to know what they're doing. Landau seems to be an absent attorney at best. Like I said, he got his service, he default judgment wrong because he got the service rules wrong. If he drafted that initial complaint, it's the worst lawyer drafted document I've ever seen. I don't know if he had a stroke or something like that. I assume he just signed off on it. Took like $500 from Maddox, signed off on it and filed it and said, if this goes anywhere, then we'll talk again about how you pay me. But, I don't think he has any idea what he's in for at this point. I think he expected maybe a quick settlement or something like that because he either lacked knowledge, didn't do proper investigation, or just didn't care. Anyway, on to Patreon's document. And, they have a short table of contents, which is fine. They have a voluminous document. It's 28 pages. We are not going to go through all of them because a lot of the arguments are repeated, right? The arguments about jurisdiction, I'm not going to dig into that. But there are new arguments here that are specific to Patreon, and we're going to go through that. So let's get into it. No more delay. Delayed enough already, right? Preliminary statement. And this you want to lay out what you're about to talk about, especially when you got an almost 30-page document. This case concerns a personal dispute between two internet personalities, plaintiff Dummy and defendant Dax Herrera. According to the complaint, Messieurs, Uzunian and Herrera had a falling out, and afterward Herrera and his fans used various internet platforms. Delicious. Including Patreon, YouTube, Twitter, Reddit, and Facebook to harass and incite harassment against Dummy and his girlfriend Dummette. Patreon and Jordan Cope, a junior Patreon employee. Poor Jordan Cope, man. That guy has got the worst deal of maybe anyone, right? Like Kaufman has a raw deal. Bozer and Baker do too, but because they're not involved at all. But at least Bozer's the founder of a presumably successful SEO company, as is Baker. Baker wasn't even served, so who cares? But Jordan Cope is a guy who probably gets paid, he lives in San Francisco, so I'm guessing he gets paid fairly well, but not really. He's just a customer service guy, right? So he's a junior Patreon employee. He's not even management, played no role in any of these alleged events. Patreon is an internet-based platform that enables just grease yourself up there, Patreon. Enables creators such as artists and musicians to be compensated for their work by their fans, and Messieurs Uzunian and Herrera are both registered users of Patreon. Mr. Cope is employed by Patreon as a creator talent lead, which means that he assists creators in interacting with their patrons, meaning he takes complaints for technical problems, right? While the 53-page complaint contains examples of harassment that purportedly occurred on other websites, it does not identify a single incident that supposedly took place through Patreon's platform. And that is... yeah. That's a problem, isn't it? Indeed, none of these claims at issue even stem from harassment that allegedly occurred on Patreon. Plaintiffs assert that Mr. Uzunian informed Mr. Cope about Herrera's conduct, seemingly after some or all of the harassment had taken place. In a series of emails, And Mr. Cope told him that he would pass the matter along to the relevant group at Patreon, Trust and Safety, that is responsible for such issues. Plaintiff's theory is that they took or refrained from unspecified actions based on these comments, and that caused them over $20 million in damages. Whatever the merits or lack thereof of plaintiff's claims against Herrera and related persons, this case is improperly brought against Patreon and Mr. Cope and should be dismissed. Absolutely. First, Patreon's jurisdiction is personal jurisdiction is lacking over Patreon and Mr. Cope because they have virtually no connections to this forum. Individuals have one home jurisdiction, right, where they have established their domicile. And domicile is different from residence. Domicile is the place that you intend to return to. Okay, so for me, my domicile is Minnesota because I have no plans to move away from Minnesota, much to my chagrin, at any point in the foreseeable future. Maybe at some ephemeral date, I will want to move, but I don't have any identification of what that is. So my domicile is Minnesota. A college student who may be going to college in Minnesota but live in North Dakota with his parents, his domicile is probably actually North Dakota because the assumption would be once he goes back or once he finishes college, he will return to North Dakota. So his domicile would be there. That's actually where he should vote and other things typically, depending on the rules of the state. But this is kind of the common law idea of domicile is where you intend to return. Now, maybe he's already got a job lined up in Minnesota, so then he'd intend to stay here, and that's the case. But corporations act a little differently. They have two domiciles. They have one where they're incorporated. And in the case of Patreon, they're incorporated in Delaware. So Patreon is subject to the laws of Delaware and always subject to personal jurisdiction in Delaware. Next, their main office location is another domicile for corporations. And in this case, Patreon's main office is located in San Francisco, which puts them at the subject of California's laws automatically. They've accepted jurisdiction in California, and they've accepted jurisdiction in Delaware. And so that's how corporate domicile works. It's a little different from personal. In this case, Patreon is a Delaware corporation, like I said, with its principal place of business in San Francisco. No relationship with New York. No offices, employees, or bank accounts in New York, other than the fact that certain of its users reside in the state. Likewise, Mr. Cope has never stepped foot in New York, not even to visit as a tourist or to connect through an airport. Like, he's got less connection to New York than anybody else, as far as we can tell. None of the alleged misconduct involving Patreon took place in New York or was directed to the state. Neither of the plaintiffs is a resident in New York, and the plaintiffs do not claim to have suffered an injury in New York. Yeah. Where are we? So we're still in the preliminary statement here. If Patreon could be sued in New York on these facts, then any web-based company that had registered users in a state could be subject to personal jurisdiction, creating virtually universal jurisdiction for internet retailers and new media companies. The courts do not like this idea. They do not like this idea. As set forth below, the laws to the contrary, in particular, the Supreme Court has repeatedly underscored that personal jurisdiction is not coextensive with conducting of business in a state. Second, even putting aside the lack of personal jurisdiction, Mr. Azunian's claims cannot be prosecuted in New York court. Mr. Azunian is a registered user of Patreon. This is interesting to me. I don't know if it's interesting to you guys. Maybe. I'm sure you'll tell me if it's not. And as such, he agreed as a condition of availing himself of Patreon services that any legal disputes between him and the company would be subject to the exclusive jurisdiction of the court situated in San Francisco, California. Should have read your terms of service, Maddox. Interestingly, a violation of any terms of service is grounds for Patreon to end your account. And the funny thing is that if they do prevail in this, Maddox's little Patreon account hopefully will be demolished, and he'll be prevented from joining their services again. I mean, that only seems comically just. Mr. Azunian also agreed to participate in binding arbitration. That contractual provision similarly bars him from litigating in this forum. Maddox is in breach of his contract with Patreon. As such, Patreon, in my opinion, should immediately terminate his Patreon account and shut it down and never let him back in. Kinster 1790. No. No to both of those questions. There's a time limit on that. I'm not going to say what you asked because this live chat will go away, and I don't want my words being used to the deficiency of any of the defendants. But no, there is a time limit. I believe it's 120 days that they have, and if they fail to meet that time limit, it is dismissed with prejudice as to those parties. So, good luck. We have tools to do this. Maddox and Landau should know about these tools. I don't know what their deficiency is. Third, the claims brought against Patreon and Mr. Cope are substantively unavailing. To take one example, plaintiffs claim they were injured because Patreon negligently failed to warn them about Mr. Herrera's harassment after Mr. Azunian lodged complaints about him with Mr. Cope. This is my favorite sentence that I've read so far. That makes no sense. What's up with my highlighting? That makes no sense. Plaintiffs would not need Patreon to warn them that Mr. Herrera and his collaborators were alleged harassers, since Mr. Azunian was the one who made the complaints and they were the victims of the harassment. I mean, obviously, right? These guys are harassing me. Why didn't you warn me that they were going to harass me? Oh my gosh. Jane Doe is also not a Patreon user. Jessica Irene Blum is also not a Patreon user. It's unclear how Patreon could have issued such a warning to her. Privity. Learn what it is, Maddox. I guess if you're watching, let me help you. Privity is a contractual relationship of some sort between one party and another. The stream of privity can go beyond the contract, right? If there's like a parent company that owns a subsidiary company, and the subsidiary company has a contract with a third party, the parent company is still in the stream of privity. But Blum is not. Notice her last name isn't Azunian, because I don't think even she would want to marry Maddox. The other claims suffer from similar infirmities and should be dismissed for failure to state a claim. Okay, so I'm going to go through the statement of facts because this is different, but I am going to skip the jurisdictional arguments for Patreon because, I mean, they're the same ones, the lack of personal jurisdiction. Patreon is an internet-based membership platform that permits creators to be compensated. Started in 2013, Patreon reimagined what it meant to be a patron. Like, what's funny is when we get to the affirmation of Sullivan here, who's head counsel at Patreon, like he says the exact same thing, and it's cited here, Sullivan affidavit, but it's like Patreon taking a moment to really toot his own horn. I don't know if Maddox or Jess are calling the shots, frankly. I'm pretty sure it's Jess. And, I mean, way to put an idiot in charge, right? Put an idiot in charge because you're a pathetic excuse for a human. Patreon reimagined what it meant to be a patron of the arts by enabling a generation of creators to transform online fan bases into reliable income. On Patreon, fans sign up to give small, regular payments, hopefully large regular payments. Come on, guys. Pony up. To their favorite online visual artists, podcasters, vloggers, comic book artists, and other creators. In 2017 alone, Patreon paid approximately $150 million to creators, helping creators grow their businesses and establish stable, long-lasting careers. I mean, I don't know if that's true. Stable, long-lasting careers seems a little lofty. Patreon also helps creators build relationships and provide exclusive experiences to their subscribers or patrons. Jordan Cope is an employee of Patreon who lives and works in the San Francisco Bay Area. Mr. Cope joined Patreon in 2015 after graduating from Falmouth University in the UK. Yeah. I mean, this guy's what, like 24, 25 years old? Plaintiff Azunian, Defendant Herrera, Defendant Kokonos, and Defendant Burt are registered users of Patreon. Each has a page on which they host content for their patrons. According to the complaint, Monsieurs Azunian and Herrera used to be partners and collaborated together on a podcast. Yeah, they used to be partners. Remember that, Maddox, in your trademark suit. That doesn't help you. collaborated together on a podcast entitled The Biggest Problem in the Universe. And just a brief aside on the trademark suit. Maddox's attorney filed his complaint as evidence in the trademark suit, which isn't effective. It's not effective evidence. However, I think since he raised the issue, that would allow Dick's trademark attorney to file the responses of all defendants, all of them being of the understanding that Dick and Maddox were in a partnership. Like, the short-sightedness of these guys is stunning. At some point, their relationship deteriorated, and defendant Herrera and others allegedly used various internet platforms to harass and incite harassment against Uzunian and plaintiff Jane Doe. Remember, the best thing that Patreon can do for themselves is to distance themselves entirely from this. They don't care whether the allegations are factual or correct or anything. They don't care at all. The most important thing for Patreon is to get out. Get out of this. We have nothing to do with these dummies. We have nothing to do with their stupid dispute. We don't know anything about their fans. They just happen to be users of ours. We don't have any investment personally. And remember that part of Maddox's argument is that Patreon is favoring Dick over Maddox, which logically they should. Dick makes them money. Maddox makes them dick. So Patreon should. But their argument in court is going to be, we have no favoritism towards any of our registered users. We hope that all of them are successful, and we treat them fairly, and we provide them the same access to services that anyone else has. And as such, we have no interest in their argument. While the complaint contains examples of harassment that took place on other websites, it does not identify a single example of harassment that took place on Patreon. Rather, plaintiffs state that Mr. Herrera's podcast is available through Patreon, and that he and his collaborators communicate with their fans, thus purportedly inciting harassment. Notice they have to include this in a parenthetical of their own device because Maddox didn't actually allege where the harassment incitement took place. Through his podcast and a variety of other social media and internet platforms, including Twitter, Facebook, YouTube, iTunes, they have i-tunes. Come on, Patreon. It's lowercase I, uppercase tunes. Reddit, Kiwi Farms, and Internet Relay Chat, also known as IRC, for people who still live in the 90s. Thus, Patreon is only one portion of Mr. Herrera's online presence. On 7 occasions, Mr. Uzunian allegedly contacted Patreon to complain about Mr. Herrera's conduct. He exchanged emails with Mr. Cope, a creator relations lead, who is tasked with assisting content creators on the platforms such as Mr. Uzunian. Mr. Cope responded to these emails, let him know that Patreon takes a complaint like his seriously, and that he would pass. In Maddox's case, they take complaints like his serially, so that was not a misspeak. Don't you dare try to call me on it. Let him know that Patreon, and he would pass the information along to Patreon's trust and safety team, which is the cuckiest sounding team I can think of. Please, I will refer you to our trust and safety team, where they will coddle you and hold you and tell you everything will be okay. Patreon allegedly never informed Mr. Uzunian of the results of the investigation by its trust and safety team. Whiskey. According to the complaint, Mr. Uzunian and Jane Doe suffered over $20 million in damages as a result of this alleged course of conduct. They brought claims against Patreon and Mr. Cope for negligent failure to warn, fraud, deceptive trade practices, and promissory estoppel. Promissory estoppel. Okay, that's a term of art, and I'm gonna get with you on this. Promissory estoppel is a very hard to enforce contractual provision, in which someone makes a promise and then another party reasonably relies on that promise to their detriment, forming a contract without an equal exchange of forfeiture of rights. Okay, so when I create a contract with one of you, I say, I promise to do this so long as you promise to do that. Now, we've each forfeited some right that we had. We had the right to not do whatever we're promising to do. Or in some cases, you promise not to do something, right? I promise not to bang you, your wife, right? I promise not to bang your wife if you give me a cat. I don't know. It doesn't matter. The court doesn't care what the value of the respected respective consideration is what it's called. The respective consideration is. They just care that there is consideration. There is an equal forfeiture of rights in the eyes of the party. I'm exchanging this for that, and we're both okay with this. Okay? If you're both okay with it, there you go. Promissory estoppel is not that. It's where one party promises something. It says, if you, I promise to do this for you. I will do this for you because of this. You don't have to do anything. I just promise to do this for you for this. And you can reasonably rely on that promise and take action to your detriment. For example, and these are really hard examples because these are almost never enforced. But like, say a wealthy relative says, you know what? Someone wins the lottery. They win the lottery and they say, you know what? You've always been a friend to me. You've always been counsel to me. You've always helped me out in my time of need. I just won $50 million. I promise, because I know you and your wife really want a down payment on a house. I promise to give you guys $50,000 to help you out with that down payment. I want you to go buy that house, that dream house. I want you to tell them that you've got $50,000 coming from me. Okay? And it really has to be that specific. It has to be that specific where you entice them to enter into an agreement to their detriment and then you don't follow through. I didn't give you the $50,000 because I didn't, even though I told you I would. And not only that, I told you to go buy on that house and rely on my promise. That's how far Maddox is going on this. And I'm out of whiskey in my glass. And I'm getting a little fired up here. And so I am going to do, this. I've got a brand new bottle from the same place, 45th Parallel Distillery. This, though, is bourbon. And I'm going to drink some bourbon. And you guys just have to wait for me to open this overwaxed seal here. Because I don't care about professionalism. I'm going with bourbon. So anyway, because my glass needs to be full. If anyone's got a question, feel free to ask it now while I'm fiddling with this stupid bottle incompetently. Do I have a knife? I do. So if you've got a question, drop it in the chat right now, and I can answer it. It'd be best if it's related to this lawsuit, but if it's not, I'd understand. I'd be okay with that. Oh my goodness. Maybe I should have picked my other bottle of whiskey. No, Clay. Except with you, and you know that. What couch? Jeez. Oh my goodness. So I am having to cut through this wax seal because they waxed over the little tab that helps you open it. I got it. Okay. No, I have not had any Japanese whiskey. I've had a couple people recommend some to me. What do you got coming? Yes, you should definitely bust out the Knob Creek for this stream. Absolutely. That's my legal advice. The worst that could happen for Maddox if the judge determines that he lied is sanctions where he would have to then pay all of the legal fees of the court. And my vacuum cleaner is right here. It's right there. Still there. Yes, I will go over the James Damore lawsuit. That is coming. I was hoping to get this out this week, but all of these documents came out, and so it's kind of delayed things. So there we go. It's bourbon time. I love that sound. Hope you guys do too. All right. Okay. No, Fireball whiskey isn't whiskey, and you know that. You know that, you coward. Clay, stop drinking beer and drink a man's drink. Whiskey. Whiskey, whiskey, whiskey. I'll put on the Indiana Jones hat after this drink of bourbon. Okay. I gotta stop reading the chat because I'll sit and talk to you guys all day. And I'll do some live stream chats with you as well. But thanks for indulging me while I inefficiently open that bottle of bourbon with this Christmas gift I got from my wife, which is this multi-tool. It's a hammer and a knife and pliers and all sorts of stuff. I like it. This is my first sip of this. What movie title best describes Maddox's situation? I'm going to get back to you on that. Let me think about it. Shameless. Wait, that's a TV show. Does that even count? Okay, stop being interesting, guys. The Lindsay Lohan GTA lawsuit. I have heard of it. I didn't actually read up on it. But maybe that's something to do. Why do I have so many kids? I don't know. I don't know how they keep happening. Okay. Let's see. He'd pass the information along to the trust and safety team. Let's pick up where we were. Patreon allegedly never informed Mr. Azunian of the results of the investigation by his trust and safety team. According to the complaint, this is pretty good. Mr. Azunian and Jane Doe suffered over $20 million in damages as a result of this alleged course of conduct. And that's important here, folks. They're laying out just how stupid it is that Maddox is suing Patreon for $20 million. Maddox, if he were being reasonable, could have maybe sued Patreon for $10,000, $15,000, something like that. We suffered damage because you guys faulted us. You guys caused us harm in some way due to your negligence. But $20 million? Nonsense. And again, it's probably due to the drafting error because Maddox is so incompetent. All right. They brought claims against Patreon and Mr. Cope for negligent failure to warn, fraud, deceptive trade practices, and promissory estoppel. Specifically, plaintiffs assert they were not warned by Patreon again about Mr. Herrera after Mr. Azunian contacted Mr. Cope. They further allege that Patreon and Mr. Cope deceived Mr. Azunian. They tricked me! By Mr. Cope stating that he was referring the matter to Patreon's trust and safety team, and that he would inform Mr. Azunian as to the status of the investigation, and Mr. Azunian purportedly relied on these statements. However, none of these statements are alleged to be false when made. That's a problem, right? Like, if I tell you I'm going to do something and then don't do it, that would make it a false statement. If I intended to not do it in the first place. And that's kind of what's required here. And Mr. Azunian, I'm going to call you Dummy. And Dummy does not state how he allegedly altered his position based on the statements. Right? If you're alleging that you relied on a statement to your detriment, how did you alter your position from your initial course of action? Because you have to change what you would otherwise do. And Maddox doesn't say how he changed what he would otherwise do. He doesn't say anything. Finally, plaintiffs claim that they justifiably relied on Patreon and Mr. Cope's vague promise to, quote, do something relative to plaintiffs' complaints. But plaintiffs do not express how they relied on the promise to their detriment. So here's the argument. Lack of personal jurisdiction over Patreon and Mr. Cope. Neither of them have been in New York. None of them do anything in New York. Nobody's subject to New York. Great. Boring argument. Not boring because, like, it would be fine. Certain defendants in this action have sought dismissal on the basis of, among other grounds, CPLR 327 and the doctrine of forum nonconveniens. For the sake of brevity, that argument will not be repeated herein, but Patreon and Mr. Cope join them in contending that this action has no nexus to New York, and all factors that courts consider when conducting a forum nonconveniens analysis weigh in favor of dismissal. So man, wouldn't it be nice if they just did this, just footnoted the whole thing? Okay, now we're on to the argument that is unique. This is unique to Patreon and Jordan Cope because Patreon and Jordan Cope have a contractual relationship with Maddox, and it's through an adhesion contract. Let me give you full disclosure. I hate adhesion contracts, but the court does not, and they are the law of the land. They are the law of the land. So if you have an adhesion contract and you agree to it, you are currently, under current law, bound. I don't know how long that's going to last. They've been here for a while, but recent cases like the doctor who was punched in the face on the United Airlines and everybody else who was punched or mistreated by United Airlines, those adhesion contracts really come into question. And there are some cases, I think one of them specifically is Royal Caribbean, and it is an adhesion contract, and it does question choice of law provisions. So I don't know if Maddox is going to raise that or not. I don't know if Landau knows anything about it. But there is a Royal Caribbean case out there, which basically I think is one of the only successful cases against adhesion contracts and choice of law provisions. But the circumstances were vastly different than what we have here. Anyway, so adhesion contracts are disgusting, but they are the law of the land. They are allowed. And when you click agree on that internet agreement, you're typically bound by it outside of some really crazy stuff. His claims can only proceed in California court. Mr. Azunian's claims implicate the Patreon terms of use, which he agreed to as a condition of his joining Patreon and continuing to avail himself of the platform. Mr. Azunian became a Dummy became a registered Patreon user on June 3rd. In registering to use Patreon services, Dummy explicitly agreed to Patreon's terms of use by checking the box next to the statement, "You agree to our terms of use." Okay. Which were provided by Hyperlink. This conduct created a click wrap agreement, which is valid and enforceable contract. See Moore versus Microsoft. Explaining that by clicking the I agree icon, the defendant offered a contract and the plaintiff accepted. In New York, click wrap agreements are valid and enforceable contracts. The terms of use established at courts located in San Francisco, California are the, quote, exclusive jurisdiction and venue for any legal proceedings. Plaintiff's counsel has so here's the footnotes. Plaintiff's counsel has represented that Plaintiff Jane Doe is not a Patreon customer and therefore has not agreed to the Patreon terms of use. Yep. But she's also not in privity with Patreon, so she's not afforded any sort of duty by Patreon. Not that Maddox is either, but she certainly is not. Maddox would at least have an argument. The terms of use provides that California law, excluding its conflict of law provisions, govern these terms and all other Patreon policies. Because to the defendant's knowledge, there are no material differences between New York and California law on the relevant issues for this motion, utilizes New York legal authorities. Foregoing choice of law analysis because the laws of the two jurisdictions were substantially identical. Basically says this has to be brought in California under contract. We need to be dismissed, and if he wants to sue us in San Francisco. In New York, forum selection clauses, which are prima facie valid, prima facie means on its face. Lawyers use a lot of stupid Latin terms. We should get rid of them. Honestly, we should get rid of them, but we don't. Prima facie valid are enforced because they provide certainty and predictability to the resolution of disputes. Right? If you're a business, you need certainty and predictability in the resolution of disputes because as a business, you're typically open to more lawsuits than an individual. And if you're a multi-state business, you're open to lawsuits in several other states. And by narrowing down the amount of forums, you reduce the cost and increase the efficiency of the business. And therefore, that benefits the consumers of the business as they don't have to pay as much for onerous legal fees. The quote, very point of a forum selection clause is to avoid unnecessary motion practice over personal jurisdiction and venue, which is what they're doing right now. Unnecessary motion practice. This is setting up the request for attorney's fees because they violated a specific provision of the contract. Stupid move suing Patreon, you dumb idiot. Thus, it is the policy of the courts of this state to enforce contractual provisions for choice of law and selection of a forum for litigation. Quote, holding that since the forum selection clause addresses jurisdiction and contains mandatory venue language, the clause fixing venue is enforceable. Quote, in New York, mandatory clauses are prima facie valid, and where parties have contracted for exclusive jurisdiction in a particular forum, it is the policy of the courts to enforce these provisions. Absolutely. Absolutely. Because Mr. Azunian voluntarily agrees to the courts of San Francisco, California as the exclusive jurisdiction for any litigation. Guys, Age Jesus is legit. He's on Reddit. It's pretty obvious. That wouldn't be his name in the live chat. It would be the name of his YouTube channel, by the way. Venue in New York is improper. His claims against Patreon and Mr. Cope should be dismissed pursuant to CPLR 3211A1, and any further legal proceedings should take place in the Superior Court of California, County of San Francisco. Footnote. As used herein, terms of use refers to the user terms that are effective as of November 1st. There are minor differences between the arbitration provision and the pre-existing user terms and the terms of use, but those are of no moment here. In signing up for Patreon, Mr. Azunian agreed that Patreon could update its user terms and that his continued use of the service constituted his acceptance of any and all changes. And by the way, this is part of why I hate adhesion contracts, because part of the contract is you agree to all changes of the contract that you may or may not be aware of. But they're the law, and that's the law. His lawyers should know and should not have filed against Patreon in New York. He shouldn't have filed this at all. And he shouldn't have filed this against anyone in New York except maybe Asterios and Weber Shandwick, but he should have filed a separate act, probably in LA or San Francisco or some court that has jurisdiction over the rest of the parties. New York obviously doesn't. But because he did, and he did it in violation of the contract, he's going to lose. At least on this one. And he may lose costs. I hope so. A contractual forum selection clause is documentary evidence that may provide a proper basis. Like they're hammering on this contractual provision to choose the laws of San Francisco as the proper venue for everything. And there's a reason they do this, because it works. It's effective. I'm going to skip the last citation because it's the same thing. Let's read these footnotes real quick. We'll read footnote 5 because it pertains to the previous section. Yes, there are other lawyers as dumb as Landau. There are other lawyers as dumb as Landau. Just so you know. And it's a sad thing. Mr. Cope is entitled to enforce the forum selection clause against Mr. Azunian, even though he is not a signatory to the Patreon terms of service. Because he is a Patreon employee and is a defendant in this action only by virtue of his employment, it was reasonably foreseeable that Mr. Cope would avail himself of the forum selection clause in the event of litigation. In such circumstances, non-signatories can enforce a forum selection provision, C.E.G. Bernstein. Employee can invoke the forum selection provision. Like, this is not hard. Patreon and Cope should not be in this lawsuit in this forum. They shouldn't be in a lawsuit. Real quick, Age Jesus. Yes. It's pretty brutal. Lawyers have stylistic choices in how they approach things. And I think, obviously, Weber Shandwick's it has been the most brutal so far. I have not read all of Patreon's complaint, but it is absolutely disdainful and dismissive in the same ways. But, not all lawyers have the same flair. Like, if you want an example, just look to the Supreme Court. Scalia's opinions are hilarious to read, whether you agree with them or not, and they're entertaining. Other justices like Kennedy, Alito to some extent, Ginsburg, Breyer, oh God, kill me. Those guys are boring. They just don't have the stylistic flair. But this is every bit as dismissive and brutal as the other ones. It's not as fancy and fun in some of the sections, but I think people are just tired really of seeing the jurisdictional complaint or the jurisdictional argument over and over. It gets boring. That's why I skipped it in this video. It gets boring to read the same basic argument over and over, but they all have to make it. That's the unfortunate thing. Everybody has to make the argument, even though it's the same for all of them. Okay. Even if venue is proper, dummy agreed to arbitration. Oops. Even if venue in New York is proper, Dummy's claims against Patreon and Mr. Cope cannot proceed in this form because they're subject to mandatory arbitration. Let's hit that footnote. Mr. Cope is also entitled to enforce the arbitration provision because he is employee of Patreon, and Dummy's allegations, oh my goodness, against him are intertwined with the allegations against Patreon. Okay, I'm not going to read the citations, not important. In agreeing to the terms of use, Dummy acknowledged that if a dispute arose with Patreon that could not be informally resolved, dispute must be resolved by arbitration. If you don't know what arbitration is, it's where you hire basically a private judge and have a pretend trial. And a pretend trial that is contractually binding by agreement of the parties. Now, that private judge is usually some sort of registered arbitrator. They're neutral to the argument. And they will listen to the facts and neutrally decide who wins. But it's funny let me digress for a second. It's funny in cases like Patreon, because typically when a business forces you into an arbitration contract, they force you to use the arbitrator of their choosing that they pay for. So is he really neutral? I don't know. I don't care in this case because Maddox is a pile of garbage. And that pile of garbage deserves all of the prejudice we can possibly muster against him in arbitration. Anyway. Administered by, quote, JAMS. Under the JAMS Streamlined Arbitration Rules and Procedures. I don't know who JAMS is, but it's probably an arbitration board or party that has set up a set of rules similar to the court rules, and that they're generally agreed upon by lots of different people. Here, the parties' agreement to arbitrate any disputes was explicit, unequivocal, and must be enforced according to its terms. Arbitration is favored in New York as a means of resolving disputes, and any alternative dispute resolution is favored as a means of resolving disputes, because here's the legal secret. Nobody wants to be in court. Not people, not lawyers who aren't people, not judges who definitely aren't people. No one wants to be there. No one wants to. Judges want to write opinions that matter, but they don't want to do it through a court process because it's boring as sin and it takes forever. Lawyers don't want to do that because while they collect fees, wouldn't it be much better to negotiate everything out, get it off your plate, and collect a ton of fees anyway? And people don't want to be in court because it's the worst time of their lives. An agreement to arbitrate is presumptively valid, and courts ordinarily resolve any doubts as to whether a particular dispute falls within an arbitration clause in favor of arbitration. Boom. And then we get to the exact same thing we see in everywhere else, but I am going to go through it because these claims are different claims than the other people's. So bear with me. This is what I do. Cause of action should be dismissed for failure to state a claim. On a motion to dismiss, while, quote, the court must accept the facts as alleged in the complaint as true. So they're going to take every fact that's alleged as to Jordan and Cope as true. So everything Maddox says, they're going to say, yep, we're going to think of this as absolutely true, and then we're going to determine that Patreon and Jordan Cope are entitled to win. And they should do this. And they should do this for every single person. It is axiomatic that factual allegations that consist of bare legal conclusions, bald legal conclusions, or that are inherently incredible or unequivocally contradicted by documentary evidence are not entitled to such consideration. Remember before that they specifically said that their own claims fail internally. They fail the internal consistency test. We can't have failed to warn him if he had to tell us who was harassing him. How could we warn him of someone that he told us was harassing him? Not only are the factual allegations in the complaint conclusory and unsupported, they do not support any of the claims that the plaintiffs have brought. Now, when you want to see the brutality of Patreon's response, again, it's muted and it's masked a little bit in the language that they use not being overly dramatic. But Patreon's best defense is to say all of these guys have their thing and we have our thing and we have nothing to do with it. So we don't care if the allegations are correct or not against them. But listen to this. They do not support any of the claims that plaintiffs have brought. They don't limit that to Patreon. They say not one of this stupid idiot's claims, not one is valid. Not one is supported. All of them are dumb. All of them. Thus, even if the court had jurisdiction over Patreon, Mr. Cope, Mr. Azunian's dummies claims could be brought, and dummies claims could be brought in this form, the complaint should be dismissed for failure to state a claim. I'm not going to read that footnote. It's boring. Negligent failure to warn. Let's look at this. Negligent failure to warn is a products liability tort that does not fit the facts of this case. Products liability, negligent failure to warn. This is like the chainsaw will saw through your genitalia if you try and stop it, right? This is airbags will not deploy if someone under 100 pounds is sitting in the seat. So don't have someone under 100 pounds sitting in the seat expecting to be protected by an airbag. This is products liability. This isn't even in the realm of Patreon services to Maddox. As is particularly relevant here, there can be no valid claim for negligent failure to warn where the plaintiff is already aware of the relevant hazard. As one court explained on this point, quote, it is well settled that there is no necessity to warn a customer already aware through common knowledge or learning of a specific hazard, or where such risks or dangers are so obvious that they can ordinarily be appreciated by any consumer to the same extent that a formal warning would provide, or where they can be recognized simply as a matter of common sense. Quote, the duty to warn of a product's danger does not arise when the injured party is already aware of the specific hazard. As plaintiffs concede, Dummy was the person that complained to Patreon about the harassment by Mr. Herrera and his collaborators, and they were the victims of the harassment campaign. Thus, they were clearly aware of the harassment and required no warning. This is basic logical failures, and if you're familiar at all with Maddox's work, you are familiar with basic logical failures. The man is a failure of thinking, of thought, of intellectualism, of expertise, of college, of business, of monetization, of everything. He fails over and over and over. It is disgusting that a man with the potential that he had in the late 90s has failed. And the only thing I can think of is I got nothing. It's just pitiful. It's just absolutely pathetic. A pathetic, disgusting failure of a human. Thus, they were clearly aware of the harassment and required no warning. Moreover, the hazard that is online harassment, including the extreme harassment described in the complaint, is a potential danger that is common knowledge and certainly would have been known to sophisticated users of social media, such as plaintiffs. You're a professional social media pile of garbage. Of course you know that people are going to harass you online, and they didn't even include, probably because they don't know, that he built his career harassing people online. Plaintiff's theory fails for the additional reason that they do not allege that a warning about Mr. Herrera and his collaborators would have been effective in preventing an injury. Quote, dismissing failure to warn claim for failure to allege proximate causation. Again, you have but-for causation. What's a but-for, right? Which is basically the idea that something causes something else at some point. But proximate cause is a reasonably foreseeable outcome from one event to cause another event. Running a stop sign is the proximate cause of getting in a car accident in that intersection. Leaving your house in a car is a but-for cause. Had you not gotten in the car, you wouldn't have gotten in the accident. But the proximate cause, what caused the accident, intervening in the but-for cause, is the proximate cause, and that's running the stop sign. Plaintiff's theory fails... Even if Patreon had sent plaintiffs a warning that Mr. Herrera and his collaborators appear to be engaging in harassment, there's no additional protection they could have taken to avoid the hazard that they did not already undertake or had not been previously informed of. For example, Patreon's community guidelines note in bold print that if one is the victim of online harassment and threats, he or she should inform local law enforcement, not Patreon. Maddox, you stupid moron. If you were actually being harassed, you would have contacted law enforcement because they're who deal with this. And even though they wouldn't deal with this because cops are relatively useless in online harassment, like, not to denigrate law enforcement officers, but what can they possibly do? Someone called me stupid online. Who cares? They don't care, but they will take a report. They will provide an incident report, and that incident report is presumptively valid in a court of law. You flipping idiot. Why you don't do this is because you're stupid. Nothing else. Anyone who's actually alleging that their entire lives are being destroyed and that they're in fear for their personal safety legitimately calls the police. That's what a normal human does. And I know whatever autism you have prevents you from being a normal human, but even that shouldn't prevent you from calling the police if you think you're in danger. But you don't think you're in danger. You're on a vindictive, childish, petulant tear because you're a man-child who can't live on his own. You have to live in an apartment with 14 other people because you can't pay rent, because you couldn't keep a job at a flipping telecommunications company, because you couldn't pass college, because you can't do anything, because you couldn't write a book for a flipping decade, because you couldn't capitalize on having a marketable brand in any sort of way that would benefit you, because you're dumb. You bought a fake crown and put on a fake cape and rented a fake chair to sit in an apartment and play Call of Duty because you don't even have good taste in anything. And you suck at rendering Sonic online, you coward. With respect to Jane Doe, Patreon also had no duty to warn her because she's not a Patreon user and it had no way to contact her. Absolutely. Fraud. To establish a cause of action for fraud, plaintiffs must plead with particularity. With particularity. Something that your complaint doesn't do because you don't allege any facts. You just allege a bunch of conclusions. Patreon Mr. Cope knowingly made material false representations. That's the whole part of fraud, you dumb idiot. Not incompetence. At worst, you can say Patreon was incompetent in providing the services they promise you. But if you're stating that they had no intention to help you, not a single bit of intention to help you, then they didn't commit fraud. Or, well, no, if you're stating they had no intention to help you and lied to you, you have to back that up. You have to back that up with something. But the fact that they have a garbage trust and safety team means that they probably did intend to help you, even though you had no merit. That's the real conclusion. You stupid man. Man? That's an insult to men. God. They intended to defraud. Again, fraud is a crime of intent. They have to intend to screw you over. Yes, this was intended to be patrons only. And yes, I did not set it up correctly. But actually, Hot Snaj, I blame you. It's your fault that I didn't set it up correctly. And maybe next time you'll think about that. 3. Mr. Azunian reasonably relied on the material false representations. We already know that that he didn't rely on anything. He didn't change his course of action in any way. And that Dummy suffered damages as a result thereof. We know he didn't suffer any damage. His book's a failure because he's a failure. His podcast is a failure because he's a failure. And his stupid YouTube channel is shedding people faster than I'm earning them because he's a failure. And whenever people are reminded that they're subscribed or paying him, they stop doing it because they realize he doesn't put out anything the quality that he used to. Or maybe they just grew up and they realize that he's not actually funny or insightful. Or maybe everything was dispelled in the biggest problem in the universe when he didn't understand a basic sentence. Clay, the fact that you're not a Patreon is a travesty. I hate you. I hope you die. In the nicest way. You owe me a retainer anyway. Plaintiffs failed to satisfy at least 3 of these pleading requirements: the existence of material false representation, reasonable reliance, and causation. Plaintiff's fraud claim fails in the first instance because they have not identified any actionable misrepresentation or omission. Now, mind you, any one of these, this is the way these work. Any one of these fails and the whole claim fails. One of the 4-part test fails, the whole claim is gone. You should unsub. Just saying. There are 3 statements made by Mr. Cope specifically identified in the complaint, none of which is alleged to be untrue at the time when he made it. 1. Mr. Cope, quote, advised plaintiff Dummy that he would let him know of the trust safety team's decisions relative to his complaints. 2. That quote, he had forwarded all of the information sent by Dummy to Patreon's head of trust and safety. And 3, that he, quote, would quote, be raising it in person at our weekly meeting. 2. Plaintiffs do not plead that the second and third of these statements are actually false. While they allege that Mr. Cope was not a member of the trust and safety team, that has no bearing on the veracity of the aforementioned statements. As for the first statement alleged to have been made by Mr. Cope, it is a non-actionable, quote, expression of future expectations. While Mr. Cope stated his intention to update Mr. Dummy, it was evident that this intention could change as unknown future events unfolded. These types of representations, which are, quote, merely expressions of future expectations or that are promissory in nature at the time made and relate to future actions or conduct, are insufficient to support a cause of action for fraud. Quote, dismissing fraud claims where defendants, quote, did not make knowing misrepresentations or omissions of material fact, but at most made promissory statements regarding future payment. As stated, promises are not contracts and are not enforced by the courts. They can't be. They can't be enforced by the courts. Because people break promises all the time, and if everyone went to court for it, it'd be ridiculous. It'd be more ridiculous than the thought of Clay Early delivering a pizza on time. And we all know that doesn't happen. While Mr. Cope stated his intention to update Mr. Dummy, it was evident that this intention could change as unknown future event. Oh, whoops. I went back. Sorry. The fraud claim should also be dismissed because plaintiffs do not allege with particularity how they reasonably relied on these purported misrepresentations. Again, you have to be specific. You have to be specific. While plaintiffs assert in a generic fashion that Mr. Dummy justifiably relied on Mr. Cope's misrepresentations and omissions to his detriment and was subsequently damaged, that is insufficient to state a claim for fraud. How? How are you defrauded and how are you damaged? What decision did you actually make? Were you induced to buy something? Did you invest money? What did you do? What did you do? You didn't do anything because you don't do anything. The claim should be dismissed because plaintiffs have not specified how Mr. Cope's statement that he would update Mr. Dummy on Patreon's investigation caused the latter to take or refrain from any cause of actions. The fact that Dummy continued to email Mr. Cope and other internet websites obsessively, like a jilted woman, about Mr. Herrera suggests that he did not sit idly by and wait for Patreon to provide him with an update. Nor would such a course of action have been defensible. In no way in this situation could Maddox either act or not act and be in the correct. That's what they're saying here, and that's funny. The Patreon terms of use set forth that the company, quote, does not screen or endorse any content, and that, quote, removing content or terminating accounts is not an action we take lightly, and we may take a while to investigate or open the issue up for further discussion with the community. Given Mr. Azunian's explicit agreement that Patreon may take time to investigate a complaint, he was not justified in waiting for Patreon to take any steps with respect to Mr. Herrera. Quote, reliance on oral statement was not reasonable given conflicting contractual terms. Quote, dismissing claim or contradictory statements in the parties' negate the plaintiff's claim that they reasonably relied upon the alleged oral misrepresentation by the defendant. Finally, plaintiffs have not alleged how they were damaged by Mr. Cope's statements, which is an independent reason that the fraud claim should be dismissed. Deceptive trade practices. And this is funny because this subheading has a footnote. While plaintiffs seem to suggest they could bring a deceptive trade practices claim under both General Business Law 349 and an unspecified provision in the Federal Trade Commission Act, they are mistaken. Quote, courts have uniformly rejected the claim that a private right of action to enforce the FTC's requirements exist. The FTC requirements are enforced by the FTC, not by a dumb idiot in California. As a preliminary matter, the GBL 349 claim must be dismissed because New York Court of Appeals has held that it only applies to misconduct that took place in New York. Nothing happened in New York. Why did you choose New York as a forum, you short-sighted short man? I don't even care if you're actually tall. You're short to me. To qualify as a prohibited act under the statute, the deception of a consumer must occur in New York. Why didn't you include a single affidavit? Not even one of a person from New York. Not one affidavit of a person in New York was included in your complaint. You stupid, stupid person. Because only two persons were purportedly deceived by Patreon and Mr. Cope were domiciled in California, the statute has no application here. They should have probably stopped there. But in any case, there are multiple other reasons that the claim should be dismissed. Multiple other reasons, y'all. 349 is consumer protection statute, and courts limits its application so as to prevent, quote, a tidal wave of litigation against businesses that was not intended by the legislature. To state a claim under GBL 349, a plaintiff must allege, quote, consumer-oriented conduct. Maddox is not a consumer of Dick's content. That is, quote, well, and maybe I guess they're talking about Patreon, but they're not actually he's not actually a consumer of Patreon in this case. He is a partner or whatever of Patreon's service. Not, whatever. That is 2, material misleading, and that 3, plaintiff suffered injury as a result. As noted above, plaintiffs have not alleged that Patreon and Mr. Cope made any actionable statements. Thus, there is no deceptive conduct that could serve as a basis for such claim. They also have not alleged an injury, as the complaint is devoid of any allegations that the purportedly deceptive conduct caused an injury. Ooh. The court should also dismiss the claim because plaintiffs have not alleged, quote, consumer-oriented conduct. 349 is for the protection of consumers, and courts consistently require the allegedly misleading acts to, quote, have a broad impact on consumers at large. Not just you. It's for everybody. The statute is limited in its application to those acts or practices which undermine a consumer's ability to evaluate his or her market options and to make a free and intelligent choice. Accordingly, where the purported misconduct is not directed towards the consuming public, 349 claims should be dismissed. That's done. I'm going to stop on that one. We're getting to the end of the document here. I'm getting tired of reading these. This is so flipping bad. It's so flipping bad that everybody has the same argument, and it's actually exhausting to keep reading them. And they're all the same. They're all the same because Landau and Maddox didn't put a shred of research into this. Didn't put a shred of effort into this. I don't know if Landau even knows New York law. I really don't. At this point, I'm starting to be convinced that he has nothing. Nothing. Promissory estoppel. To establish a claim for promissory estoppel, it must be shown that the defendants made a clear and unambiguous promise upon which the plaintiff reliably relied to his or her detriment. This claim should be dismissed because plaintiffs have not alleged a specific promise and, as with their fraud claim, they have not pled facts to show reasonable reliance or actions taken to their detriment. Do we need to go on, folks? I mean, we don't. We don't need to go on. Let's take some highlights here. Let's find the quotes, because this is what we're looking through. It, quote, cannot be construed as clear and unambiguous promise to make the mortgage loan. This is citing an earlier case. That's boring. Here we go. As for Mr. Azunian's purported reliance, he fails to allege any actions that he failed to take based on Mr. Cope's statement. Plaintiffs merely claim that Patreon, quote, strung plaintiffs along for months on end without any resolution. While plaintiffs may have been frustrated by these alleged events, mere delay does not support a claim for promissory estoppel because it does not give rise to an actual injury. And that's the whole thing. They state a $20 million injury, but even accepting every fact, let's accept every fact is true. No, Clay, that's a terrible plan. If we become Patreons of each other, we're just giving Patreon money and losing money for ourselves. I will not do that. I will not. You will become a Patreon of me or nothing else. I don't accept that contract. Even if we take every allegation in the facts as true, every single one, Maddox has failed to articulate where the damage numbers come from. He doesn't cite failed book sales. We all know his book is a massive failure. We all know his book is a massive failure. Massive. It sells less than Dick's book, which has been out for a decade and is not trending. That's how pathetic the book sales are for Fasterisk whales. Okay? So he can't... But he didn't take the moment to tell the court, who doesn't know that the book sales are a massive failure, that they're a massive failure. Probably because of his narcissistic pride. And the fact that if he admits it's a failure in public, then he admits to being a failure. Maddox, it doesn't matter if you admit it or not. We all know. Even your listeners know you're a failure. Even they know. And I know there's only like a couple hundred of them left because I look at your poll numbers, man. They're not good. For the reasons stated herein, plaintiff's complaint against Patreon and Mr. Cope should be dismissed in its entirety. Alternatively, Patreon respectfully requests that this court issue an order compelling Mr. Azunian to arbitration. That's funny, because if the court compels him to arbitration, he may have to pay for it. Oh, for violating the terms of service. Anyway. Can't sue me for slander. My statements are protected. So here's the affidavit of Colin Sullivan, and these are pretty short. I'm not going to go through the whole things. I just, they're kind of funny. I, Colin Sullivan, am head of legal at Patreon, corporate defendant in the action. As such, I have personal knowledge of the information presented herein. I graduated. Yes, Tomekeeper. Sorry, I'm taking a question from the chat. Landau is at risk. I don't want to say how much risk he's at because I am not... One, I don't practice in New York. I have no idea what the courts do as a matter of practice upon lawyers. But under the rules, he is subject to sanctions for the incompetence that he's shown in bringing a frivolous action. Okay? He's definitely subject there. Depending on his relationship with Maddox and the business agreement that they entered into, Maddox may have a claim against Landau. We can't know because we don't know what Maddox asked Landau to do. We don't know what Landau agreed to do. In Minnesota, I mean, this looks like a frivolous action. Sorry, I'm answering another question. Someone asked, what would it be in Minnesota? In Minnesota, he would be at a high risk, because what it looks like is he took no interest in the claim, that he signed a document and filed it on behalf of someone else based on nothing. He would have to have a really solid retainer agreement with that client. And even that retainer agreement would be suspect, right? Matthew Osborne, is that claim incompetent counsel? Maybe. maybe it would be incompetent counsel, but it might also be fraudulent misrepresentation of legal services, right? Let's live in a fantasy land where Maddox didn't write the complaint and Landau did, and Maddox paid him a substantial sum of money to write the complaint. If he did that and Landau produced this incompetent pile of garbage and maybe didn't have Maddox review it for authenticity and didn't discuss the deficiencies with him, then, Maddox may have a case of fraud or a breach of ethical duty against him. It's hard to say. It's really hard to say what the actual claim would be. But, and it's really unfortunate. Lawyers protect their own, right? Lawyers are the ones who sue lawyers, and lawyers are the one who make judgments against lawyers. It's usually the Bar Association making an ethical decision, or their ethics board, and that's a bunch of lawyers. We police our own, and there's some fault in that. I'm not going to sit here and claim that the lawyer ethical obligation is perfectly enforced. It's actually imperfectly enforced to a large degree, but that's that. As to Fat Hipster, could Maddox appeal for bad counsel? Probably not, actually. There's a distinction between having bad counsel that costs you a case and appealing that as to the defendants. It's not the defendant's fault that you have bad counsel. It's the bad counsel's fault or your fault, one of those two, and your claim is against your attorney, not against the defendants. You can't bring the defendants back into court when your counsel failed to bring them in. So, that if this is dismissed and if Maddox successfully argues bad counsel, it's probably not going to be held against the defendants. Yes, Clay, we are. Okay, so I graduated from the University of Pacific McGeorge School of Law in Sacramento, California. I co-founded Indie Voyage, a crowdfunding game label that helps developers with their planning, production, marketing, community management, and quality assurance. Before that, I founded Crowd Counsel, a law firm focused on crowdfunding and intellectual property law. Now, what's funny is, he founded these companies. Are they still around? I don't even know. In November 2015, I became head of legal at Patreon. Good step up, by the way. In-house counsel for a big company. Hopefully you get paid well. Patreon is an internet-based platform that enables creators such as artists and musicians to be compensated for their work by their fans. Patreon was launched in 2013 and reimagined what it meant. Oh my gosh. Reimagine what it means to be a patron of the arts by enabling a generation of creators to transform online fan bases into reliable income. On Patreon, fans sign up to give small, regular payments to their favorite online visual artists, podcasters, vloggers, comic book artists, and other creators. I still don't know what a webcomic is, and I refuse to acknowledge their existence. In 2017, Patreon paid approximately $150 million to creators. By the way, if you just go ahead and take 5% of that, that's Patreon's revenue, presumptively. So they're not actually that big of a company. Smaller than I thought. Thereby helping them grow their businesses and establish stable, long-lasting careers. Patreon also helps creators build relationships and provide exclusive experiences to their subscribers or patrons. Patreon is Delaware LLC, blah, blah, blah. This is interesting. Approximately 4% of Patreon's user base, which includes both creators and patrons, is located in New York. That is shockingly lower than I would expect. That is shockingly lower than I would expect. I would expect a much higher percentage based in New York, because New York's a town of pretentious artists. Based on the associated IP addresses, an IP address is a numerical label assigned to the networking device. There you go. Jordan Cope is an employee of Patreon who lives and works in San Francisco Bay. He joined Patreon in 2015 as creator talent lead. This was shocking to me, guys. Plaintiff Maddox joined Patreon as a registered user on June 3rd, 2016. I thought his Patreon account was... I thought his Patreon account was older than this. That is pathetic. That's pathetic, man. All registered Patreon users are required to agree to the terms of service. So here's an interesting thing. I read this before, so I'm going to summarize and synthesize the next couple parts because it's boring to read. Basically, Maddox agreed to a term of service, and those terms of service have changed from June 2016 to now. And what Patreon makes the argument here is that there are no significant differences between the 2016 terms of service and the 2018 terms or 2017 or whatever terms of service that exist today. The only difference is that the arbitration rules that they agree to are different. First, they originally required them to agree to the arbitration rules of the American Arbitration Association. Now they require them to agree to JAMS, but that doesn't matter, because the rules are probably substantially similar. And the other permitted either party to enforce the arbitration clause. So originally, when Maddox signed up, either Patreon or Maddox could demand arbitration under the contract. Now, Patreon just requires it for everybody. So everybody is subject to the arbitration clause. In any case, even if everybody were not subject to the arbitration clause, Patreon had the pre-existing right to demand arbitration under the old contract. They're substantially similar. There makes no difference whether you're using the original terms of service or the current terms of service, and they're just defeating that argument in advance in this affirmation. That's it. And then, here are the exhibits. I'm not covering the exhibits because reading through terms of service makes me want to kill myself, and no one wants to kill themselves. Affidavit of Jordan Cope. Look how short this is, guys. This is funny. So we're going to go through. I, Jordan Cope, and am a defendant in this action, have personal knowledge of the information presented herein. I was born and lived most of my life in the UK. In 2015, I graduated from Falmouth, a specialist university for the creative industries based in Falmouth and Penryn, Cornwall, England. In or about October 2015, I moved to California and joined Patreon Inc. as a creator relations talent lead. In that capacity, I helped established creators launch a Patreon page on Patreon. He didn't help me. I'm going to sue Jordan Cope for not helping me. I'm a resident of the state of California, and I've lived in San Francisco Bay Area for more than 2 years. I have no connection to New York. I have never visited New York in any capacity. I have never even visited a New York airport through a connecting flight. He's never been in the state. Get out. You're done. You're done. This is the affidavit of Christine Olsen, or affirmation of Christine Olsen. She's the attorney that works for Patreon in New York. Doesn't say anything other than she works for Harris St. Laurent and Chandri LLP, counsel for Patreon. And then she attaches the exhibits. I mean, this is it, guys. Again. Massive failure on the part of Maddox. Massive failure on the part of Landau. Absolutely worthless in what they've done. So I'm going to take this time. The live stream's been going for 1 hour and 37 minutes, which is kind of long. If you guys have any questions, I know you're a couple seconds behind me here, drop them in the chat. Drop them in the chat. I'll gladly answer any questions about the lawsuit. If you got any other questions, I'm happy to answer them as they're appropriate or inappropriate, as it were. I've had a couple drinks. I'm willing to say, some inappropriate things. So just let me know what you got. And I will wait just a few minutes for the chat to catch up, because you guys are slow, but not as slow as Maddox. Yeah, he is a failure, guys, over and over. I can't state it enough. Just imagine yourself in this situation, because no one's in this situation. No, I can't. I physically can take my shirt off, but I won't on the stream. Not right now. Sorry. I would be open to collaborating with YouTuber Law, but let me make this point real quick. Picture yourself with 400,000 fans and what you could do with that. Not everybody's a creative person, but it doesn't matter. Imagine if you had 400,000 people willing to listen to you at any given moment, and you fail. You fail to turn that into money. I think a drunk mime from New Orleans could turn that into money. Okay, now I'm going to answer questions. How'd you defeat Vinny from My Cousin Vinny? It's impossible. Because, well, actually, no. it is possible to defeat Vinny from My Cousin Vinny, because you would want to research. Like, there are several dubious statements that he makes about his qualification to practice law, and that's how you'd have to do it. You'd have to do it in that way. That movie is actually a very good representation of how evidence is presented, unlike most legal movies. So there you go. Yes, Asterios and both Dick and Patreon and Weber Shandwick can get a judgment for costs against Maddox. Okay, but a judgment doesn't mean you actually get to recover, because Maddox probably doesn't have any money. But once you get a judgment against him, you could levy wages, you could garnish payments from his book sales. You could put a lien on his book sales. You could put a lien on his tax returns. There are ways to get money, but probably not enough, because again, he's a failure. How do you prevent something like this happening to us? Don't be popular. That's it. That's the only way. Is the room ever going to be cleaned? No. I would love to clean it, but I've said a couple times, this is a storage room in my house. It's where I keep my computer and where I hang out, when I'm playing games or whatever, which is happening a lot less since everybody's filing documents at the same flipping time and ruining my leisure time. But it's hard to clean this room, because this room is actually where stuff goes to die. Someday I'll do a tour of this room just as a fun video, but it'd be really hard to clean. Where is the hat? You're right. I did not bring out the hat. Here's the hat. This is my Indiana Jones hat. It's actually my kids'. It does not fit me correctly. It is not worth their time to file an action against Maddox. Based on everything we know, Maddox doesn't have any money. So what are you going to win? Anything they're going to win in this case. Clay, 4 wipes. Okay. Let's see. He has Marissa Tomei. Yes, he does. Hi, Alan. What's going on? What movie, TV show has the worst representation legal system? Literally all of them. They skip all of the boring, horrendous parts of our job, which is filing paperwork, writing boring papers. They skip to the cool stuff, which is, making arguments in court. And it's not that cool. Like, there really aren't surprises. Everybody knows what you're going to say. The surprises come when your clients fail in various ways. Like when your clients admit to something that they shouldn't admit to, and you can try and mitigate it on your own, you've got your examination of your client, and they've got cross, and then you've got a chance to rebut the cross examination, but you can't always recover. And if your client admits to something, it screws everybody over, and there's just nothing you can do. But it's not really shocking or surprising. There are certain cases that can be very animated, but most of them are really boring, y'all. What would happen if Maddox dropped the suit tomorrow? I don't know if a judge will let him drop the suit tomorrow, because summary judgment motions have been filed. Dropping the suit tends to be a dismissal without prejudice. And if a judge were to allow it, he may actually require consent of the parties. I don't know if that's going to happen. If a judge allowed him to drop the suit tomorrow, he could probably raise it in California. Because, like I said, voluntary dismissal is usually done without the merits. But voluntary dismissal after all of the defendants who have been served have pleaded their responses, not likely going to happen without judicial permission. And I don't know if the judges would grant permission to dismiss this without prejudice. Yeah, I agree with you, man. When you're trying to become a lawyer and you see someone who's doing just a shit job at it, it's really frustrating. It's really frustrating for me as a small town attorney, because I don't get cases like this, right? I get cases that are contract disputes. I get cases that are, I get cases that are evictions of various sorts. I get stuff like that. And to see like the potentially large lawsuit here, and to see some guy probably making, some money. He's filed motions, so he's making thousands of dollars on this either way. It's really frustrating. Who makes the best hammock? No idea. Yes, it is the reason why many people hate lawyers. I just realized you had a second a second follow-up there. I deal with this all the time, like having to overcome the stigma of being a lawyer by being a decent human being, by listening to people and trying to help them out. That's part of my average day. How much money could this cost Maddox? I mean, a lot of money, hypothetically. Like, okay, for each of these documents, think about the lawyers that are being hired in New York. You're talking probably $400 to $500 an hour lawyers. I'm guessing. I don't actually know, right, what any of their rates are. But let's assume $400 an hour. Each of these lawyers has drafted a 25-page research document. They've read a 53-page document. It took me 2.5 hours to go through the 53-page document. That's $1,000. What? That's $1,200, right? $1,250. I don't know. I'm not good at math. I'm a lawyer, right? It's $1,250 just to go through the document to read the complaint. Then you've got to draft a complaint. And drafting a 25-page complaint, you're talking 5-6 hours minimum plus research time. Massive amounts of money. Maddox is potentially on the hook for 50-60 grand if all of the defendants were to win all of their legal fees. It would be disgusting. No, Clay, you cannot be sponsored by Nike. Yes, it could end him. If dismissed, would we find out? Yes, absolutely. The court will issue a judgment dismissing the case. I will cover it. So follow my channel and I will definitely do that. Yes, the room is where my liver goes to die. That's true. Let's see. Am I sure I'm not an alcoholic? I actually don't drink a lot. I drink during these, and outside of that, I don't drink much. But I think this case is making me into an alcoholic, if that's a thing. Let's see. People calling themselves to the stand is tough to do. I don't know if it happens in district courts where you do see it as conciliation courts and they don't call themselves to the stand. Usually the judge calls them to the stand and the judge does the questioning, but then the other party is allowed to do cross-examination. Not recommended. Don't ever go to the stand in front of a judge because then a lawyer's going to do cross and you're going to get screwed. Clay Couch. I have not watched Better Call Saul. Sorry, I will watch it as soon as I can. It looks super entertaining. I loved Breaking Bad. I'm assuming Better Call Saul is good. Let's see. Yeah, I agree. I'm surprised that George hasn't sued more people. Really, George should have sued some of the fans. Like they had online identities at least, and they should have named them as plaintiffs. Even if they couldn't find them, they should have named them. I think that would have given credibility to the complaint. Let's see. Clay, your question about prequels isn't a question. Dummy, did Maddox write that for you? I don't know what it is with YouTube lawyers and funny hat shenanigans. These hats belong to my kids, actually. And they just happen to be sitting here because this is a storage room. I do not like the shtick done by, what's his face, the other YouTube law guy who does the hats. Alan Foster, there is always a slim chance of someone winning. There's always a slim chance of winning in court because courts are ultimately decided by people. It's unfortunate, but that it is. That's how it is. Yes, these fuckers do charge by the hour. All lawyers typically charge by the hour, and they charge a lot. I don't charge a lot at all. I'm a small town lawyer. I work by myself. I don't have an assistant to pay or anything like that. So I try and keep fees down because personally, I don't like the prohibitive cost of the legal system, and I'm tired of seeing bad people or good people in bad situations, and I try and help them out where I can. Yes, Clay, it is racist. Let's see. Alexander Hamrick. I'm sure Hamrick. Sorry, Said that Asian style, right? I'm sure that it is higher in New York, but I don't know what these people's fees are based off, and I like to, when I'm using numbers, I like to make conservative estimates. So that's why I picked the $500 an hour. I know those guys can actually go up to $2,500 to $3,000 an hour, depending on the fees that they're charging and who they are. Will I play the Maddox loss theme when the case is dismissed? I think so. I want to get it redone to because his lawyers suck, right? Yes, Clay, it is. Still considered shitposting. Chris W., is there anything to stop Maddox from doing this over and over just to drain cash from Dick paying for lawyers? Every subsequent lawsuit contains a risk of sanctions. And those sanctions don't always just include legal fees paid by the parties. Eventually, those sanctions can show a contempt for court and ultimately can result in jail time. So there is a detriment to him doing this over and over. Yes, Clay, I'd do a shot with you, whether you were a hologram or not. My personal favorite lawsuit that happened. I don't know. There's so many that have happened. And looking at different lawsuits, it's hard to pick one because some of them are really frustrating, even though I love any time that people sue the United States government and prevail, but I love when they sue the government and fail too, because we need to check state power. I'm a libertarian of some stripe, right? Whatever that means, but state authority bothers me. So I absolutely love when people sue the U.S. government. A good one is actually cited in one of the cases I've covered before. I can't remember which suit it is, but or which video it is, but it was a case where President Truman, he tried to nationalize the steel mills, and that was struck down. That's a great case because it stopped the government from nationalizing, even in a time of war. And that's just a good thing. We don't need the government nationalizing countries. Whoa. What is your opinion of arbitration? Arbitration is a great thing. Honestly, arbitration is great because the court process is slow, it takes forever, and it's expensive. Arbitration can be cheaper. Usually, if it's a person arbitrating against a company, they're arbitrating on the company's expense. Usually the company is the one paying for it. Arbitrators are usually retired judges, and arbitration is binding. Alternative dispute resolutions are good things because the court process is a bad thing. Even if you win, sometimes what you win isn't worth the victory that you could have gotten through settlement because ultimately you pay your lawyers a ton of money and the stress that it puts on people is awful, and I hate that. Nothing happens to Maddox. Or Maddox. Nothing happens to Maddox. Maddox. Nothing happens to him at this time, James, to answer your question. I do a ton of pro bono cases. Don't you call me nasty words. I'll call you some back, Grimpify. How much would I charge you per hour? Like I said, I live in a small town. It's hard to justify more than about $150 an hour. That's probably what I'd charge you, Clay. I'd probably charge you $250. No, I don't have any terrible commercials advertising my law firm during daytime TV. All of my advertising is done by word of mouth. Who is Clegg? I don't know. A lot of people think he's a pedophile. 10 shots, Clay. 10 bullets. Let's see. How long do Maddox's lawyers have to respond? They have, I don't know. That's a good question. Typically they would have 5 to 7 days probably before the hearing request. And if you notice, each of these people have in their notices of motion, and I haven't been covering them because they're really boring and they don't say much, but I think January 28th is Dick's motion request, if I remember right. That may have been Weber Shandwick's. I don't remember. Weber Shandwick's might have been the 31st. But I think January 28th is the first one. They have until probably 5 to 7 days before January 28th to respond to the motion. So we should see something from them very soon if they respond. If they don't respond, they're going to lose. If they do respond, they're probably going to lose. Nick confirmed for Tea Party. No. Not a Tea Party. I don't affiliate with any party or anything. I typically, in the past, have voted Republican. That's not to say I'm overly happy with Republicans in general. I didn't vote for Libertarians. In the recent election, I voted for me because as the only competent person I know, I'm the only one qualified to lead the country. So you guys are all welcome to vote for me in 2020. I'll be running again. Making a Murderer. My thoughts on that are I need to watch it. But from what I've heard, man, there are really problematic murder convictions that have happened in this country. The beyond a reasonable doubt standard is messed up, and if you have seen my video on the law enforcement bias, which is shooting Shaver, right? Making a Murderer is part of the example of the law enforcement bias in action. People get convicted based on false allegations by law enforcement officers, whether that's cops, whether that's attorneys, prosecuting the cases, whether that's judges, whether that's, anybody who works in that system has the potential to be impacted by the law enforcement bias, and some people go to jail, and they may be guilty or not. I don't care, right? This is the hard part for people to get their minds around. It doesn't matter if they're guilty or not. What matters is if the state has done an adequate job in proving their guilt. And when they short circuit that, pisses me off, man. Yes, nationalizing is what Hitler did. Let's see. I'm going to have to slow this down. So what is my maximum hat capacity? Infinity. How many cops does it change to light bulb? None. They'll just beat the room for being black. I'm stealing that joke. That's the funniest things I've ever seen. Hate the Nate. I'll do a video on McCulloch versus Maryland sometime. I'm not going to answer it on the stream after this many drinks. Cause yeah. Oh my gosh. Clay, if you OD on alcohol, I will sue myself, but I'll lose. Tomekeeper, you may be thinking about the trademark case in which their initial disclosures, I think, are due by February 8th. So that might be what you're thinking of. I don't know. And again, I'm not familiar with the New York rules. Anything you see from me about New York rules is researched, usually a little bit before the stream, and I take or before the video. And I don't want to dig too deep into it because I'm not going to become an expert in a short amount of time, and I don't want to come across like I'm giving legal advice to anybody. So I get to rest in my non-expertise with a little bit of security for myself. Yeah, well, Hamrick, let's talk about that. Maybe I can get licensed where you are, and then I'll charge you a super cheap rate because my overhead's low as hell. Let's see. All right. Yeah, Clay, come to Minnesota and hang out with me, by the way. I cannot run in Canada. I mean, I guess in theory I could get, I can run in Canada. Can I? For, for Prime Minister against Trudeau. Man, if his name was Judo, he'd be much more effective, I think. I'll see about that. Maybe I can get dual citizenship. My favorite chaos god is Korn. Blood for the blood god. Skulls for the skull throne. If I want to be the living man and deem the flag as the Jolly Roger, what's the best way to represent myself in court as a sovereign citizen? Ask in court if you're being detained. That's the best way to do everything. And also scream and tell the judge that you don't accept his authority. I'm not going to Road Rage Portland. I just can't make it. Chicago is actually a big stretch for me. My baby is still very young, and I like to be around to help my wife, and I like to hang out with my kids. I am hoping maybe to organize a family trip to Dallas for Road Rage Dallas. I don't know when that will be, but that is near my. I have a lot of family in Texas. I'm from Texas originally, so if that works out, maybe. You can add me on Steam. Absolutely. I don't know what my Steam ID is. Let me pull it up. I'm going to do that. While I do that, I have not been playing Diablo 3, so I can't do more speedrun vids. Those were mostly for me and a couple friends. Whatever. That's just how it goes. I like Diablo 3. It's fun, but I just haven't had time. What is my Steam name? Oh, I think my Steam name is Ankle Chewer. ENKLECHEWER. So add me. I'm with you. If you're ever arrested in Minnesota, call me. Yes, absolutely do so. I just took on 3 drug cases, so that'll be fun. And I'm hoping to do some case postmortems as I get permission from my clients. Okay. That'll be something that I'm doing only for Patreon subscribers at the moment, mainly because of the sensitive nature of the topics. I would never advocate unpledging to Larry Clay. Let's see. I think I answered the next Road Rage is Portland. I won't be there. Lionel Hutz is definitely more competent than Kevin Landau. Cody, go back and watch the whole thing. You know what? Cornel stab Nurgle, and you know it. It's my go-to porn search. Patreon only. My go-to porn search is just searching for myself on YouTube. Let's see. I can't distinguish who's my patron and who's not, Clay, on here. Let's see. So I'm libertarianish. What guns do I own? I own a SIG 516. I own a Winchester 243 that was given to me by my grandpa right before he died. And I own a Springfield Colt 45 1911. My wife owns a SIG P238 Lady, which is a fun 380 auto. I think that's the extent of guns that we own. At least the ones that I'm willing to disclose on the stream. I don't live in the last dry county in Minnesota. What are you talking about? Yeah, Cody, if you're a $50 Patreon, I told you I'll send 80s girl's name to you in different accents. I am not aware of the lawsuit against Encyclopedia Dramatica. I'll try and check it out. Maybe, I'm going to be covering a lot of these social media lawsuits that are coming out. All right, guys. If Germany were to attack a NATO ally, what would NATO do? I think NATO would probably cry. That's a really interesting question, Grimpify. I'm not familiar enough with the World War II articles and how that would impact. What gun does my wife's son own? Nerf guns, buddy. But that's also my son. How many RPGs do you own? All of them. Yes, subscribe to the Dick Show subreddit, I guess. All of my exes do not live in Texas. All of my exes probably live in Minnesota because I spent most of my older childhood here. I am covering the Damore versus Google thing. Had everybody on Earth not filed the lawsuit today, you'd already have a video on it. I'm hoping to do it this weekend. I don't know if it's normal for Americans to have more than one gun in possession, but what I do know is that the Americans who do own guns tend to own more than one. So let's see. All right, guys. No, I will not be buying the Dark Souls 1 remaster, probably because I just don't have time to... I don't have time to play games very much. What I play right now, and if you guys want to play with me, I'd be happy to do it sometime. To my $20 Patreons, I'll actually do it and do like a full law Q&A and discussion and whatever, and record it. and stuff. So if you want to do that, you're welcome to do that, and we can post it to YouTube, and that'll be fun. I play Total War, Warhammer 1 and 2 a lot, and I'd be happy to play with some other people. And I play PUBG a little bit, but not a ton. And I play Diablo. So I'm happy to play any of those games or other games too, but I don't have a lot of time to play games right now, mainly with my starting the stream and trying to keep up on top of it. Anyway, guys, love you all. I'm going to cut it now. I'm going to do more of these live streams, although they're supposed to be reserved for Patreon, but my incompetence at doing that has probably foiled this one. I am going to do more public live streams as well. But we'll see, and probably at more accessible hours. So just stay tuned. Lots of content coming out for the channel, and I am not the guy who's going to put out one video every 2 weeks on you. I love doing this so far. So keep watching. Tell your friends. Send me around. I mean, the growth has been far beyond my expectations on this. If you got anyone who you think would be interested in this stuff, share my channel, have them watch a show. I am going to keep trying to interact with people as much as possible because I really enjoy it. So, let me know what's going on. Help me grow, and I'll keep providing tons and tons of content to the point where you get bored with it. So anyway, talk to you guys later.